Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City, and in this video we're continuing our series on the E-2 investor visa by focusing on the requirement that the E-2 business must be a real and operating commercial enterprise that will provide a service or product once the visa is issued. There are a few aspects to this requirement that are important to keep in mind in any E-2 visa application, and that will be our focus today. Before we dive in, if you're interested in more information about the E-2 visa requirements, we have posted to our YouTube channel our full webinar on the E-2 visa, which we'll link to below. We also share a lot of free information about the E-2 visa and other visas on our blog, which we'll also link to below. Finally, please remember that no video can replace the value of working directly with an immigration lawyer who can navigate the specific nuances of your application. So with that, let's get started. There are a number of requirements that must be met before an E-2 investor is granted a visa. One of these requirements is called the real and operating requirement, which states that the E-2 business must be a commercial enterprise that will provide a service or product once the visa is issued. There are a number of aspects of this requirement that are important to pay attention to. First, let's look at the requirement that the business must produce a product or service. This means that the business cannot be, in the words of the government, a paper organization or an idle, speculative investment held for potential appreciation in value. In other words, the primary purpose of the E-2 business cannot be to hold property, stocks, or some other asset in the hope that it will appreciate in value. This is one of the main reasons that real estate investment companies and other asset management companies face such high rates of denial. In the government's view, passive investments are not real and active. This leads to a bit of overlap with both the develop and direct requirement and the marginality requirement, both of which we cover in separate videos. In summary, the develop and direct requirement states that the E-2 investor must be coming to the U.S. solely to develop and direct the E-2 business, meaning growing demand for the business, hiring and supervising employees, etc. A business that's based on a passive investment would likely fail to satisfy the develop and direct requirement, since a passive investment typically would not require that the owner or investor be actively involved in developing and directing the business. Also, it's usually not necessary to hire workers to support a business that's primarily focused on a passive investment. This would cause the business to fail the marginality requirement, which states that the E-2 business must employ U.S. workers. While there are examples of businesses centered on passive or speculative investments that do require that the owner actively develop and direct the enterprise and hire workers, this is not always the case, and the government applies additional scrutiny to any business that appears to primarily engage in passive investments. The E-2 investor who plans to start a real estate or investment business can anticipate this scrutiny and reduce the risk of denial by taking additional steps that show that the business will employ workers. For example, the applicant can show that their clients will go beyond their friends and family, and that there's sufficient interest in the business to clearly show that it will be active. Also, the applicant will want to show that they've acquired all of the necessary licenses to act as a client-oriented business. Real estate businesses can be approved as well, and it's especially important to show that they will operate in a way and on a scale that requires hiring workers and is not limited to serving as an idle or speculative investment. The real and operating requirement also states that the business must provide its product or service once the visa is issued. The consular officer wants to see that the E-2 business is either already operating or will be ready to operate as soon as the E-2 visa is issued, and that the only thing preventing the business from providing its product or service is the issuance of the E-2 visa. One way to show this is by providing documentation with the E-2 application that shows that the investor has purchased all of the items that are required for the enterprise to be operational. Specifically, we recommend including specific documents in the E-2 application in order to show the consular officer that everything is in place for the business to begin operating as soon as the visa is issued. That the business has been created as a legal entity, that the business has secured office space, that all licenses and permits have been issued, and that the company has a website that can immediately begin generating interest in its products and services. Also, if possible, the applicant should show that the business has already executed contracts with prospective clients. It's not necessary that the business generate revenue before the application is submitted. In fact, our firm has successfully represented many E-2 applicants who have not generated a single dollar of revenue and have not hired a single worker before their E-2 application is submitted to the government. In these cases, though, the government will accept a business plan that provides 5 years of hiring and financial projections. For those companies that are already operating when the E-2 application is submitted, the business plan is less important since they can show that they are real and operating by providing tax returns and payroll records that demonstrate that they're generating revenue while employing workers. Remember that the consular officer wants to be satisfied that your business will generate sufficient revenue to employ 3 to 4 full-time U.S. workers within 5 years of operations. It's okay if that process starts only after the E-2 visa is issued, as long as the business begins operations immediately after the visa is issued. However, one thing an E-2 visa will not be granted for is to search for a business opportunity. For this, entering the U.S. on a B-1 business visitor visa, or ESTA, would be appropriate. While the business visitor cannot engage in unauthorized work, both the B-1 visa and ESTA allow the visitor to take important steps that are necessary in preparation for an E-2 visa, including meeting with a business broker and business owners interested in selling their businesses, interviewing workers, entering into a commercial lease, opening a business bank account, and other activities central to starting the business. Finally, the real and operating requirement states that the E-2 business must be a commercial enterprise. This means that it must be a for-profit business. Organizations that are not for-profit are unfortunately ineligible for an E-2 visa. Instead, the E-2 investor applicant should not only plan to generate a profit, but they should highlight revenue and profit projections over a 5-year period and how those projections will support the employment of U.S. workers, both of which are key considerations for any consular officer reviewing an E-2 application and which should be reflected in the business plan. We hope this video about the E-2 visa's real and operating requirement was helpful. If it was, please click the like and subscribe buttons below to stay updated on future videos about visa options and travel to the U.S. Thank you for watching.